Hello, I'm Ben Dusing. I have put together a compilation of videos that consist of a number of videos that I've put out over the past couple of months, a select group of videos that have been compiled for a specific purpose. And that specific purpose is this. It is to collect in one place those things that are more objective and concrete, and that illustrate the things that I have tried to illustrate over the course of my library of videos, if you will, the past couple months. It doesn't really matter why I started doing that. It was for a different purpose. It doesn't really matter why I kept doing it. It was for a different purpose. What matters for present purposes is that I came to be in possession of certain materials, in my case, which demonstrate certain things, which illustrate a bigger point. The point is not my case. I'm one person. I am one example, and not that consequential in the big scheme of things, nor are any of us. But to be able to use my example as exactly that, as an example, these things as an example of a bigger point, of a systemic point, to demonstrate them not for the sake of these things themselves, but for the sake of pointing out that these things happen, and not just to me, but logically, of course, to others as well. I did not know that this was a systemic thing. I experienced these things myself in the course of my own journey. But over time, on account of overwhelming outreach directed my way, and an overwhelming interest, a clear public interest, a clear news media interest in the systemic recurrence of the kind of thing that I experienced, I came to understand that I could play a valuable role in raising awareness to the issue as a first step towards accomplishing positive change, fixing what is broken to the extent that it is broken. So, over time, I have made a series of videos. Each of them have been about different topics. Some of them I've just spoken about the subject matter. I've talked about various components, but certain of these deal with specific concrete issues that highlight specific things. I've tried to include an explanatory video that explains the circumstances and what is being shown. I've tried to include the evidence themselves, so no one has had to take my word for it or had to rely on my description of something, but have endeavored instead to show it to you so that no inferential leap need be made, and so that any aspect of my own personal credibility, such as it is, need not be attached to the message in order for the message to be credible and to resound. This is my best effort of collecting in one place those videos which concretely show certain things that clearly, while problematic if they occur in any one case, which they clearly have, clearly reflects systemic problems if they are occurring in many, and which very clearly do. For those who seek to understand what I'm talking about, this is a good starting point, and I've compiled these videos for the purpose of that educational mission. I hope it is helpful. Enjoy. One thing that we can't have in family courts is people playing games and trying to get particular judges for particular reasons. It should be about the law and the facts. And if it's about the law and the facts, who the judge is shouldn't matter. It should be about the law, not personalities and relationships. Well, in my particular case, let's just say that it's not obvious why someone would file a paternity lawsuit about a child who has yet to be born. Transparently, that is obviously playing games with the system and can be explained only by an attempt to time the filing of a lawsuit to get a certain judge. If that kind of gamesmanship is going on, hopefully we can all agree that is troubling. After all, if it's about the facts and the law, then who cares who the judge is? We should never have lawsuits being filed about seeking to adjudicate the paternity of children who have not yet been born. After all, why not just wait until the child is born? And when that happens, we have big problems with respect to whether the court has jurisdiction, and all kinds of bad things can happen in that regard. Here's another thing hopefully we can all agree on. We should not misrepresent basic facts, any facts really, but certainly not basic jurisdictional facts to a court of law. If we write in something to the court that a lawsuit was filed after the child in question was born properly, it should not turn out that we are then having to admit that in fact is not the case, that the lawsuit was filed before the child in question was born. Shouldn't lie to courts, shouldn't play games to courts. This next video is about something to do with that. Yes.
No.
Was filed before
Yes.
the child was born.
By a day or two before she was being induced, I filed it.
Okay.
Yes, absolutely. That's
Sounds
what I
like
did.
we're in agreement.
Okay, so again, a little show and tell here that might help some people kind of focus in on the point here, so I don't have to spend as much time talking about some stuff. I get all kinds of crazy stuff these days, which comes with standing up and speaking out about things that are wrong. Doing the right thing is never easy or popular, and I have to say it is actually wildly popular now. I will say that, and that's a good lesson. Believe in the people. At first, people are like, "What's going on, Ben? You're nuts." Now, Katie and I basically get asked for our autograph when we go to indoor soccer games, which damn near happened today. And that should inspire people to do the right thing, because in the end, not at the beginning, in the end, the truth comes out. So, I don't know. But typically, that's how it goes. You're going to get blasted for a long period of time. We went through that. And then people are going to get it. You just have to be sure of one thing. Make sure you're on the right side of truth. Okay? So, that's the most important part. But let me highlight this. So, let me just clear some stuff up. You got all these people. I get calls and stuff. Oh, my gosh. The family court said all these horrible things about you in this order dated April 5th, which I have in front of me. Ooh, what you got to say about that, Benny boy? Okay. Here's what I have to say about that. Whatever is in this order is probably not right, for the simple reason that it was written prior to the court seeing the evidence and hearing the parties' arguments. We don't have a very good chance of getting, findings of fact correct when the findings of fact are written before the parties' factual arguments and evidence is before the court. Everybody follow that? So I don't really let me put it this way. Doesn't move me much, okay? I didn't read this for months. All I had to see, the only thing I read on here is this date. And as soon as Katie pointed that out, we knew what was in here. Bullshit, right? And I'll explain in a second. There's no other way. That's basically the point. So what's the point? April 5th is the date when this 20-page, single-spaced opinion was written. Now, I'll just show you. It also happened to be entered on the same day. That is interesting. We did a separate video on this. Katie also discovered that. We did a whole analysis of the 126 court orders. It is so weird how out of 126 times, 34 times, the weirdest thing happened. The order that blows me up, because we've spoken out about the staff attorney and what's happened down there. She's the one that writes these orders, not the judge. Those get entered right away. It takes a lot of time typically for orders to get, usually 4 or 5 days, at least in my case. But it's the darndest thing how all these special ones get entered right away. What's the hurry? Well, in this particular case, everybody knew that Katie and I were going to New York the following morning. So, as always happens in my litigation, so weird, man. Katie, so weird. You can count on the court order coming out at just the point in time where we would be maximally prejudiced by in dealing with it. This one wasn't that hard to deal with. It's the freaking date. And the house of public corruption comes tumbling down. Why then? Well, because of these dates. See that one up there? That is the date on which the parties' post-trial submissions, their closing arguments basically, were made, containing the factual arguments and the legal arguments. Sure, we had a trial, but the court doesn't see all the evidence at the trial. There's time limitations. So it doesn't even know what the parties' arguments are in the case until their one and only opportunity to argue their facts and law to the court. And the court, and the judge, in this particular case, gave a big speech about how important these things are. And they are. They're your one and only opportunity to put your facts and law before the court. Well, ladies and gents, It was not put before the court until the evening or the afternoon at 4 o'clock of March 29th, 2021. That would be ours. Post-trial submission of respondent Benjamin Duzing. 15 pages, dense case law, endless citations. Every single thing cited in here. These are what findings of fact look like, by the way. And if the Kenton Family Court ever wants me to help them out with them, I'm happy to. No hard feelings. Okay? This is what real findings of fact look like. There's citations to the actual evidence. Here's a list of undisputed facts, okay, including the fact that the other side sent way more communications to me over the period of time that I sent to that person. Makes findings that, like, I'm domestically abusive based upon the volume of my communications seem a little bit crazy. Like, I guess the abacus is broken down there because every single one of those communications was put into the record for the specific purpose of the court taking the time to look at the evidence. And if all you have to do is look at that and say, oh, all this whiny ass stuff about how often Ben communicates is obviously bullshit, because we have all of the communications in the evidence, and there's X amount here, and there's way more than that over here. Okay? It makes any kind of conclusion that, like, like that, just mathematically stupid. And yet that is the exact conclusion that was arrived at by the court, and the justification, by the way, for denying fundamental constitutional rights. If that is scary to all of you out there who do or may have business in front of the Kenton Family Court, I would say the following. I would be fucking terrified. Okay? Take it from me. Now, don't fear. We have appellate courts. We have appellate courts for a reason. And among their functions are to make sure that family courts and lower level courts like this don't have, broken calculators. So we'll see if they can do the math. In any event, here's the other brief. You can see petitioner's closing memorandum. That's the other side's. You can see the date on that. That's March 29th, 2021, 4 o'clock. Now, let me help everybody out there with a little math. This is a calendar, okay? And as someone that has prosecuted a lot of, like, sophisticated criminal behavior, on the spectrum, I do not find this particularly clever. This is pretty easy to see right there. That is where the briefs were filed. This is when the court wrote this humdinger of a 20-page single-spaced opinion with all kinds of specific cites to evidence and all this stuff. There's 6 days. There's a problem, though. Of those 6 days, 3 are the Easter weekend, and the court was on the bench, and the author of this opinion, and the judge for that matter, otherwise accounted for during those 6 days. So really, it's 1 day. Even if it were 6, however, I think you get the point. I don't think that the court read 15 pages of some serious facts and law, and they didn't have the facts and law until March 29th. 15 pages each side, looked at the evidence, considered the parties' arguments, thought about it, consulted the law, which dictates the outcome, and wrote this big humdinger of a whatever it is in 1 day, or even 6, or even 2 weeks. It was decided in advance. And making that conclusion, while mind-blowing, a little more easier to believe is the fact that prior to the trial in the case, the lawyer on the other side told Katie that the case was, what, Katie? Decided in advance. True or false? True. So, as soon as somebody wants to come and put her under oath, she'll say that. For that matter, I was told before this litigation even began that in so many words, I felt it was a little bit stilted, that, like, I needed to do certain things, or because the person's attorney had the court, or owned the court, something like that. I confess I didn't believe that at all. But this is not fantasy right here, boys and girls. So forgive me for not being as direct about some things as I'm able to be now. you can understand that it's a little bit of a difficult thing to raise your hand and complain about cases being fixed while you have two ongoing litigations in front of that very court. Now, I don't know what else is being discussed. There's 10 other problems with that opinion, including there's findings of fact about things that were never discussed in the case, begging the question, where did you get that information? Because wherever it came from, it was totally inappropriate. That's like against the rules. And also the fact that, I don't know if you can see this, but everything in yellow, it's a lot of this opinion. Look at all that. Ooh. A lot of this opinion. Ooh, look at all that. I could go on and on. There's more. The yellow was literally written by the other side before the trial. How do you have findings of fact? Cut and pasted, by the way. Didn't even change it. About evidence that you haven't even seen yet. Yeah. So, as you can imagine, for all those out there not lawyers, you might think that is really effed up. And there's got to be a consequence for that. My response to that is, yeah, probably, almost certainly. My concern is not like people getting in trouble. It's reforming the system and accomplishing positive change. So that's what my focus is on. But yeah, and just judging by, well, the FBI's presence in the courtroom for the last hearing before the court decided to recuse, and also little bombshells like the fact that this entire litigation was initiated before the child in question was even born, something that anybody can understand is a little bit curious. Why not wait until the child's born? That's a little weird. Obviously, it was an attempt to get the special judge so that the special justice could be dispensed. And it is unfortunate, though, that this attorney happened to represent affirmatively to the court, effectively lying by saying that the person initially filed a petition for custody with this court following the birth of the minor child. Well, it wasn't until October 8th, and I put the video on Facebook so all of you can see it, where the attorney got around to telling the court the truth. So, it should surprise no one that the court took that particular moment to say, ruh-roh, I want nothing to do with this litigation ever again, especially since one possible, in my view as a lawyer, likely legal outcome of that fact, the fact being that the litigation was started, was filed prior to the human life about which it was ever existing, is that the court never had jurisdiction in the first place. And hundreds of thousands of dollars of taxpayer money were pissed down the drain. Both parties spent an incredible amount of money and 2 years of their life wasting their frickin' time, all because a lawyer, a special lawyer, with special privileges at the court, courtesy of her hookup, the staff attorney that runs the place, lied her ass off. Now, look, that happened. I understand that those people who might suffer consequence because of this are not going to be happy with me for pointing it out. But in the end, them's the apples, homegirls. You made your own stew there. I don't know what's behind me, but probably is not a Medal of Honor for either of you, okay? Let's hurry this up. Feel free to step aside. Let me clean up the mess. Let's give the people a court that doesn't fix cases. Happy Saturday to y'all. Mwah!
5 seconds. I got 2 documents right here, and one is my mental health independent examination standard of, domestic court litigants. Both sides got it. It stated June 2019. It concludes that I am fit to parent all 4 of my kids, no mental health issues. Specifically says on page 2, not bipolar. June 2019. Here's a court order. Findings of fact, conclusions of law from October 21st, 2019. After a hearing on October 8th, 2019, where this report was in evidence, discussed, all the parties have it, it's for the court has it. And this order concludes that petitioner is currently in treatment with psychiatrist twice a month. He has completed the court-ordered mental health evaluation and has been diagnosed with bipolar disorder. Come on, man. Right? Findings of somebody like, look, man's got bipolar. And then they write up a report that says the same thing. They're not going to conclude any different than the court concluded. Right? And then that person issues their report. And then when it comes time to have a trial, then you bring that person in and they testify about, just nonsense on top of nonsense on top of nonsense on top of nonsense. It's just one example, but they're all like this. I mean, if we're going to talk about findings of fact in the Kent family court, I mean, like I've got a book on uniforms in here too, if you want to do that. I mean, come on, man, is that where we are with your show? With you, but I appreciate the opportunity to talk about.
Why is the machinery of justice in my cases down at the family Kent court tinkered with? That is the question. It is not a matter of opinion whether they are or are not. They are. That has been pretty fairly observed the whole time, but this video is about the empirical proof of that. Now, I know. I am not special, and I am keenly aware of this. And the implication of that is that if this stuff is happening in my cases, it is almost certainly happening in others. That is also consistent with the dozens of conversations at this point that I've had with other litigants and other lawyers about their observations that the very same thing is going on. I just decided to prove it scientifically. So what am I talking about? Well, first you have to understand a little phenomenon down there at the Kent Family Court. Okay, there's a whole bunch of levers, all kinds of levers of justice that the petty bureaucrats who control these things, outside the eyes of the presiding judge or anybody else, or the litigants for that matter. There's a whole bunch of levers that can be pushed or pulled to kind of guide, outcomes, all right? One of those things that can help or hurt a party in the case is the length of time it takes for one of the court's orders, once it's written and signed, to be entered in the clerk's office. As a general rule, or overwhelmingly, no one knows about the existence of the court order until it gets entered in the clerk's office, and it is therefore not operative. So, it's not enough to get like preferential justice in the form of a court order that says what you want it to say. It doesn't have any operative effect until you get it entered in the clerk's office. Okay? So that's a lever that can move one way or another. So if you have a ruling that's unfair, let's hypothesize that you have a group of lawyers before the Kent Family Court that have a hookup, for lack of a better term, a good relationship, use your euphemism, with certain of the court staff members, okay? And on account of that relationship, in whole or in part, you are able to get special access to justice, meaning heard more so or quicker than the average party down there. And you're able to get officially or unofficially special justice, kind of the outcome that you want, the findings of fact that you want, the relief that you want. Let's say you have that. Okay, well, if you're able to get special access to justice, special justice, in and of itself, that is not going to do anything for you or your client. You need to get that special justice operative, and that means getting the stuff in the clerk's office. Okay, so one way to mess with stuff is if the other side, despite the fact that they have a hookup with the judge's chambers and they get special preference, special access to justice, special justice. Despite that, if there are orders that go on that are adverse to those people, well, one way to kind of screw with the system and help out that party is to delay the length of time it takes for those orders to become operative, to be entered in the clerk's office. Conversely, if you're able to get special justice in the form of court orders that say what you want to say, or even that you wrote in large measure because the staff member at the at the court's chambers in writing their opinion or order just used, say, 1/3 of your proposed findings, okay, things that you can submit to the court for their use, but which are intended for the most part, not overwhelmingly for, you're not supposed to have the parties write the orders really as a general rule. You want to get that operative right away, so you want to get that in the clerk's office right away. So you can speed that up, right? Okay. In my cases, over a huge sample size, you have the equivalent of lightning striking the same tree on the same day, again and again and again. And here's the interesting part. And that tree is always falling on my house. Okay. It's really weird that lightning would strike this many times, but if it did, what are the chances that that tree is always going to land on my house? Statistically, it should fall the other way, land on the other house, the other side's house, if it really is just a lightning strike. Okay. So here's what we did. We took all of the orders in both of my cases, combined 126 orders, which are about evenly spread out between the two cases, the entire history of them, and we extrapolated from them the date that the court issued the order, which is on the face of the order, and we extrapolated the date they were entered, which is also on the face of the order. And then we took the full amount and we took an average, okay? And the average amount of time that it takes in the one case is 4.4, in the other case 4.1, meaning 4 days, if we round it, on average between the cases, from the time that the court has a signed written order, and the time that is entered in the clerk of court's office, and then known to the public, known to the parties, and becomes operative. Whatever justice is reflected in that order becomes effective, if you will. So the average is 4 days. Well, what you see here, and I'll just show you, you see some pink and some yellow, some other things, but here's pink and yellow, okay? Now, if you notice, there's way more pink than yellow. Now, what does yellow represent? Yellow represents the high-end outliers. These are instances in which the court was exceptionally, abnormally, unusually delayed in getting orders entered at the clerk's office, okay? So I believe the yellow reflect, anything over 3 times the average length, okay? Those tend to correlate with orders that were desired by my side or grant relief that are favorable to me. Okay, and there's not many of those because there's not many of those. All right. Now, you'll notice the pink are all over the place. The pink represent instances where the period of time from the court's issuance of the order to that entry in the clerk's office was accelerated dramatically. In fact, the pink represent and are limited to instances where the court's order was issued and entered at the clerk's office either on the same day or the very next day. So 0 or 1 day delay. Given that the average on the whole is 4.5 days, that reflects a tremendous abnormality. Okay. And that's within the context of my case. If you look at it in the universe of just how things operate down there generally, there are not many orders that are being issued and entered on the same day, just because there's a lot of orders being issued by the court, so it doesn't take them down to the clerk's office every day, presumably. But even if it does, there is definitely a delay at the clerk's office because it's getting orders from all over the place. And if they just go in the normal stack and are handled in the normal course, there's going to be some kind of delay, okay? And probably longer than 4 or 5 days. So if you have orders that are being signed and somehow entered virtually immediately, that is a big time outlier. That is lightning striking, statistically. Well, wouldn't you know it, in my cases, lightning has struck 34 out of 126 times. How about that? And all of the orders in which lightning has struck, meaning that there was that the justice that was dispensed, not favorable to me, that stuff got signed and entered, got entered right away. The tree fell on my house. So, this has been observed for a long period of time in my case, and it's fairly stark. But you can always explain away a single instance. And that's the case, too, from the other lawyers and other litigants who kind of see the same thing. But this is the full universe. These are the full statistics, and they do not lie. What conclusions can we draw from them? Well, this one. That's messed up, dude. I don't know who or when. I don't know when it became acceptable, culturally acceptable, or why. This idea that it is okay to tinker with the machinery of justice and to help one side. Now, I don't know if the attitude is, we're not hurting one side. Okay, we're just helping the other. But that kind of logic is recognized as being bunked by the scales of justice themselves. If you help one side, you hurt the other. You disturb the equality. So look, in a word, it's wrong. And here's my point. This is just one example. It's just one of scores of overwhelming circumstantial proof and a few instances of direct proof that, special people get special treatment. And that ain't right. That ain't right. There's nothing more fundamentally contrary to the rule of law and to how a court is supposed to operate than that. And if we're treating people's lawyers differently, if we're giving special preferences to people's lawyers, we're giving those litigants special treatment. And that ain't right. And it's very, 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 very disturbing. I've never seen this in my career as a former federal prosecutor. Really just as a lawyer, even absent that background. this is very offensive to the concept of justice. Now, do I have a self-interest in this? Yeah, I've got cases down there, and I need things to be decided on the facts and the law, and not the usual clique for people to not get special treatment. I don't want it. Frankly, if I were offered it, I would decline it. It's wrong. Okay? And that's the problem. That's the problem. So, this needs to be addressed. It's frustrating. In my case recently, the court issued a show cause order to another attorney that was involved in the case to come before the court and answer some questions, because the court deemed a particular issue a serious issue. It had with something that came up in the 3-hour hearing where we were virtually entirely dedicated to getting, whether the other attorney was going to get paid for reasons that I contend then, I contend now. The court has no authority to grant, to order the attorney to get paid. But my question is this: if that's a serious issue, if there's a serious issue about some statement in a filing that there was no report, and then 6 later it turned out there was a report. First of all, why that's hard to understand. People were confused. Okay, I have no idea. But if that's a serious issue, why isn't this a serious issue? Why isn't it a serious issue that you've got staff members who were caught red-handed having ex parte communications with opposing counsel in one of these cases, to try and set up hearings with other judges when the judge in our case goes out of town after he enters orders that are favorable to my side, and they successfully get within a day a hearing arranged with a different judge to try and undo these orders, and they get caught red-handed. Why aren't we issuing a show cause order about that? Why aren't we issuing a show cause order to talk about what the court has acknowledged at this point, that in one of my cases, a 20-page opinion issues after 2.5 years of litigation, tons and tons of evidence, and in part denies one of those parties their fundamental constitutional rights, and the court acknowledges it never read their briefs. It never read their, if you're going to deprive somebody of their constitutional rights, don't we owe it to them to at least first hear them out? That didn't happen by the court's own acknowledgement in my cases, in at least one of them. Why don't we have a show cause order about that? Why don't we have a show cause order about the fact that you have court-appointed counselors and parties who are independent, who come before the court and who testify or want to testify or want to tell the court about how the guardian ad litem, who is a professional connection with certain staff members of the judge and the judge himself, about how this person has obstructed justice in the case, has done everything in his power to make sure that the court's order related to the expert's appointment does not get done. Why are we not having a show cause? Why are we not having show cause things about that? Okay. In fact, why is the court saying, I don't want to hear about that? Why does the court not want to hear about this? Why does the court deny evidentiary hearings about this stuff, but then we spend hours upon hours of time that plenty of other families with business in front of the Kenton Family Court who have legitimate issues that impact their family to decide? Why do we then take 3 hours to go motion by motion to determine whether the preeminent face of the family court bar in Northern Kentucky, whether they get paid, particularly when, with all due respect, the law is absolutely plain that the court does not have the authority to grant that relief to begin with? Why aren't we talking about that? Where's the show cause orders there? I think these are fair questions. So, this is deeply troubling, and I put this in the public domain for a lot of reasons, but one of which is I feel a responsibility to. I am the unusual case that allows for the collection of this kind of sample size. Never before, almost certainly, and never in the future, almost certainly, would anybody have the opportunity to glean this data to detect empirical disparate treatment from the objective statistics over such a sample size? We need courts that decide cases based on the rule of law. We need to do what's right by kids and make the courts about kids and not about attorneys getting paid. And this entire industry needs to be about doing what is best for the clients and the kids and not generating artificial conflict and having hookups down there at the judge's office and generating a revenue stream. And that's just the goddamn truth, okay? So, that's what I got to say. Thank you. Morning, everybody. Hey, just another example that was on my desk here for this, talking about the spotlight on corruption, the Kenton Family Court. Ongoing watchdog efforts that we have here to ensure justice for all. Just wanted to point this out. It happened to be on my desk. So one of the interesting things about the findings of fact in this case, now findings of fact are things, again, the practice of law is the application of facts to law. That's it. So it doesn't matter what anybody thinks, it doesn't matter what their viewpoint is, their job is to apply the law to the facts, but you have to find the facts. In family court, the fact finder is actually the judge. So in a jury trial, the facts are found by a jury, and the law, the court provides the law and then, regulates the trial, but obviously the jury comes up with the verdict. Not so in family court where the judge does all of those things. So obviously, you have, if you have an opportunity, if you have a hookup at the Kenton Family Court, the person that really does all these things, that basically writes the findings of fact and does all that for the judge, the staff member, then if you've got a hookup with that person as a private lawyer and that person's going to help you out, I mean, you can dictate the results of a case, right? I mean, you can absolutely produce justice, and that's the kind of corruption that's going on here, is legion. So one of the fascinating things is like just how cray the findings of fact are, in my case and some of these other cases, right? So, typically a finding of fact would be like this. It should be like this. If you have a witness that says the light was green and a witness that said the light was red, the court has to decide, whether the light was green or red, because that matters under the law. It only matters if it matters under the law. If it's a fact that doesn't matter for purposes of the law, it shouldn't be being decided. So, interesting here that, in my case anyway, we have 16 and 20-page opinions to find facts and describe evidence that really aren't factual findings and really are not important to what's being decided. So that's a separate, unusual thing. But in my case, these findings are, cray-cray and in these other cases. And, that's part of how, misdeeds and those with a hookup down there with Miss Keys can, dictate the result, really, of cases by, writing these findings of fact. And in fact, in a lot of cases, Ms. Keys just uses the findings that are written by, for example, misdeeds. In my case, in one example, there's an April 5th order where 33% of the court order was literally written by misdeeds, before the trial. So, it's perfectly appropriate to use, proposed findings and stuff, but it's very rare that you actually just cut and paste them and you use that many. But whatever. Anyway, in my case, you have Dr. Washam is the appointed court neutral counselor, expert witness. Was actually proposed by the other side. I didn't know him, don't know him now. Had business with him as ordered through the court, and he is in there to provide testimony about certain things at certain times. And we had a hearing way back in June or something, and the court generated a order after that hearing and issued certain findings of fact. And Dr. Washington testified at the proceeding. He actually testified, I guess you would say his testimony helped my case, And, that's not good. And for the other side, and for those who have the hookup with Miss Keys down there, who's supposed to write the fiction, if you write the fictional facts and you apply it to the law, that's how you get the right result. So what are we going to do here? Generally speaking, the findings of fact in, they're written. The only way I can describe it is it's like watching the movie Saving Private Ryan, and then like, picking up the screenplay for that movie, and the screenplay being like Aladdin. Like you're like, what? That's not what. That didn't happen. That's not what they said. Like, what's going on here? But it's one thing if it's me or the other side, right? But the court findings that described Dr. Washington's testimony, court neutral, not my side, not their side, not engaged by other side, just this is what the court neutral person, they're going to rely on this stuff. So badly did they butcher his testimony that he actually wrote a letter to the court. This is a letter dated June 25th, 2021, requesting the court to amend the findings. There's two findings in particular that he took exception to, but he called them, and I quote, blatantly erroneous, which they were. I mean, at this point of the litigation, 2 years and two separate cases, this is like what happens. But, he reads the order and like, that's not what I said. That wasn't my testimony. Why is it in a court order like that? And he asked the court, thank you for your consideration with respect to modifying the above findings of fact. In my 20 years as a lawyer, including 5 as a former federal prosecutor, I have never, ever seen this before. A witness testify in front of the court, a neutral witness, and a court-appointed person, no less, who comes before the court and gives his testimony. Again, here it happened to be, very favorable to my case. And the court just writes writes findings that are blatantly erroneous in characterizing his testimony, such that the order suggests that, he testified against me. And so jarring was this that, the guy wrote a letter to the court. But that's not the most effed up thing that happened here, because it's always like that. You always got to wait for it, right? Like, what can be more effed up than that? And here's the most effed up part. In response, the court, operating through Ms. Keys, because she really runs the whole court there, and she's the one that has the hookup with Ms. Dietz, and that's the corruption. That's how Ms. Dietz gets decisions in favor of her clients, and that's how Ms. Dietz gets access to the court that nobody else gets, right? And that's corrupt as hell and probably illegal, but that's not up to me. It's not the rule of law, and that's what continues to happen here. But what's most messed up is that the court said, when I say the court, I don't even know if the judge knows about this stuff, because Ms. Keys does pretty much all this. The judge is always confused, okay? Like, I feel really bad for the guy. He's ultimately probably responsible under the rules for everything happening beneath him. And that's really unfair, because he clearly doesn't know. In any proceeding, he's like, wait, what? I did what? Well, he didn't do anything. Ms. Keys did. Poor Stephanie. And, that's how everybody in Northern Kentucky that's gotten screwed and been the subject of this corrupt behavior, and all these clients that, keep calling us and all this stuff. And we can't do anything for them at this point, which is tragic. But this is the corruption, right? The court said no. So, no, thank you for pointing out in an unprecedented way that, like, our court order, which describes your testimony, is, in your words, blatantly erroneous. Paragraph 1 of this letter, which is in the record. Anybody that wants to go, verify what I'm saying can say that. Thank you. We're going to stick with the blatantly erroneous version. Yeah, thanks. I mean, what? That's some good stuff, man. Anyway, I just had to share that. Happy Thursday. I'll be back with some more examples. It was on my desk. I had to share it. Spotlight on corruption in the Kentland Family Court. Awesome. I think it's a really sad day when a litigant has to file a motion seeking legal treatment under the law. I think it's an even sadder day when we have a proceeding to discuss whether we're going to find it. No. I don't enjoy talking about this stuff. I don't consider it a matter of opinion whether or not parties have been treated equally by the court staff members. That evidence is before the court, and I don't enjoy talking about it. It's difficult to come before a court and say that, but to suggest that treatment has been procedurally equal is just not so. The record is now complete with example after example of the business properly going through the court's staff members and being timely responded to by its staff. The exact same business, the exact same communications, going to the court staff unanswered. In this very moment, Ms. Lawrence awaits the simple acknowledgement of a receipt. And courtesy, I assure you, the record established was extended liberally to other members of the bar during the full court. I respectfully suggest that it is entirely in violation of law for that to happen. I have endeavored to respectfully stand up and say that it's wrong, because it is. I have fully anticipated to get tarred and feathered for that. It does not change the fact that the practice is wrong. This motion, sadly, is absolutely submitted in good faith, and the evidence for the same is in the record. It's not a matter of dispute about whether the customer service provided to all attorneys appearing before this court is the same. And I think it is that fact, and that fact only, which drives the constitutional outcome. It is my intention to be respectful, but it is my intention to be strident. I submit on saying.
Your
Can't believe I have to make videos like this, but I do. Many of you have received, once again, packets, anonymous packets in the mail or dropped off or whatever. They contain a nasty note about me, referring to my obvious mental illness, mental health breakdown, talking about the videos that we've made about the family court corruption and the lies that are being told, and it's a little bit spooky. And then there's the contents of the package that contain some documents that purport to be court orders and litigation involving myself. I need to ask if anybody's received those. I would really appreciate it if you reach out to me however you want to, and if you retain these packets that have been sent out and there's tape on them, and if you could avoid touching the tape, it would be really appreciated. As you know, the FBI has been involved for a long time here, and the instructions, kind of are that's if we're going to get fingerprints, that's where they're going to come from, as I understand it. I'm really sorry that everybody receives these. They're sent to my clients, professional contacts. The intent is to embarrass me, and this has been going on for a long time. There's been previous rounds of this, but this one includes a note. Obviously, whoever's going through all of the, and we know exactly who, is going through all the time and effort of sending all these things out and putting them all together and all of this. I mean, I don't know that the problem is my lies on Facebook. I think it is just the truth. Obviously, the truth is a problem here. This is what happens in these circumstances, and I'm sorry that inconveniences a lot of other people. Standing up and doing the right thing often has a lot of consequences, and I understand that those are up to me. I really regret when they affect other people. That being said, the intimidation tactics have really ramped up over the past few weeks as a lot of this has become public. There was a court proceeding on the 8th where a lot of this was just put right in front of the court. It is what it is. I mean, I don't actually have a mental illness, and I've never had a mental health illness. But even if I did, I'm not sure that changes the facts or the truth as it's been laid out. And I don't think the FBI attended our last proceeding by accident. It's just not about me anymore. But nonetheless, this stuff affects my family, and intimidation and threats have got to stop. The FBI has been very helpful with that, and I'm asking for your help. So, just another Saturday here, my life. But it's important that somebody speak up and out, and it's got to be us. It's us, and we have. I just don't want my family to suffer because we're speaking the truth. Katie's out. Thanks.
Hello, cool cats and kittens. This is a replacement video, if you will, that takes the place of a video that I initially did, and if you recall, perhaps I intentionally used some dramatic language and some foul language, which got misconstrued and which I regret. The purpose of intentionally doing that was to draw attention to this particular email string and to make the point in an emphatic way, since we've been dealing with this issue for a long period of time, that we need to do things the right way and pursuant to the rules. and to highlight what happens when we don't. And what happens is that special people get special treatment if we don't apply the rules. So this video seeks to explain in a more sedate way, a more infomercial way, that which, given that I've put a lot of videos out there and I don't want to be monotone about it, my antagonistic, sort of bombastic approach may have misconstrued. So the email strings relate, of course, to some emails that were sent back and forth between certain private counsel and certain judicial actors in connection with the pre-ruling docket. The pre-ruling docket is something that is unique to the family court situation, from what I understand. Has to be understood on some level to fully grasp kind of what's going on here. But there are specific rules that are in place in connection with the pre-ruling docket. Some are written policy, some are local rules. But there is, as there is for everything, a rule-based / law-based specified procedure for handling issues that come before the court. Here is not how we handle things. We just email an actor at the court, and we don't have private litigants having communication with judicial actors about the subject matter of kind of off the record. Okay, that's not any part of the specified process, which is spelled out in the local rules. And we certainly do not have judicial actors not named the judge essentially issuing judicial rulings and granting relief to private litigants. Number one, they're not authorized to do so. Number two, they could get it wrong. And here we have an instance of both. So the email in question begins with an inquiry from a private lawyer involved in one of my litigations. Again, we're using my litigations as an example. It's not the problem. I'm not talking about this stuff because it's about me, but it's a good way to illustrate the larger systemic issue, and clearly it is a systemic issue. The attorney on Friday, October 29th at 3:14 p.m., after the pre-ruling docket had come out, sends an email to the judicial actor indicating that her particular motions had been left off of the pre-ruling docket. Now, some background is necessary here, but anybody who has some background knowledge here would, I think, agree that it's surprising that of all the attorneys to have their motions omitted somehow from, or overlooked from the pre-ruling docket, it is somewhat hard to believe that that would happen here, but let's assume for a moment that was the case. We have then, and a previous email was sent at 3:14 p.m. on a Friday. Excuse me, it was sent at, yes, 3:14 p.m. on Friday, October 29th. Now, at 3:49 on Friday, October 29th, an email is, the judicial actor in question responds to that private attorney and says, thanks, they will be added to the pre-rulings to be called. Now, you have to have some background knowledge there to understand what that means. But what that means is that those motions will be heard. Here is that email at the bottom there. Okay. That email was sent 25 minutes after, let's see here exactly, 3:14 and 3:49. That is 35 minutes, right? After the initial email, and presumably, and there's no indication given that they would be, that the judge kind of passed on those. It is a matter of logic, but also a matter of local rule that, of course, the judge has to make the pre-rulings. We elect the judges to make the rulings. They can have assistants, they can have staff help them make the rulings. That's well and good, that's necessary, but the judge has to make the rulings. And when we start letting other people make the rulings, especially without the judge being aware, that can be problematic, obviously. It puts a tremendous amount of power in the hands of judicial actors who are not authorized to act independently. Now, Ms. Lawrence saw this on Friday, October 29th at 4:04 p.m. and she responded. This is the top here.
and notes her objection for the record. And she states her objection for the record, which you can read, and is, now hold on a second, everybody else had their motions listed on this pre-ruling docket. Presumably the judge signed off on that. Now we've got a private attorney emailing after the pre-ruling docket came out and saying, oh, we missed some orders there, mine weren't on there. That's not how you, first of all, it's not an objection, okay? We're not allowed to just comment with judicial actors on rulings. We're not like, that's not part of it. We can object. That's part of the process, but that's not really an objection, problem one. Number two, there are specified rules as to how you handle an objection, one of which is not that the judicial actor involved just decides herself to give that private attorney, to put those motions on the docket. That's part of the pre-ruling process, to decide whether or not they will be on the docket, and if so, how they will be on the docket. So the objection is made. Now, that is at 4:04 p.m. Now, Katie has been objecting to this for a long time. We can speculate as to why, in this particular instance, there was some follow-up. There never had been prior in the past. But suddenly on Monday, November 1st, at 3:13, the judicial actor involved responds, and that's in the bottom there. Counsel, Judge Mailing has reviewed the two pending motions for clarification. Per Judge Mailing, the pre-ruling on the motion to clarify is changed to denied. So now we have a motion that the judicial actor had set to be heard on Tuesday, that now that presumably the judge is looking at things, the constitutional officer authorized to do so, suddenly that's not happening. That private litigant is not having that motion heard. That motion on its merits is denied. That is a dramatic swing. Let me recap. Private lawyer and private judicial actor raising the issue off the books, not in the way prescribed. What does it get? It accomplishes the motion being heard, being put on the docket. Compare that to when the very same thing is addressed by the judge per Judge Mailing. Okay, the judge himself, the constitutional officer authorized to actually do this stuff, and by rule required to do this stuff. The very same thing, the outcome is denied. The motion doesn't get heard. So even simpler, private actor contacting judicial actor on the inside the wrong way, not in conformance with the rules, and the wrong outcome is obtained. A motion that should not be heard on the docket is heard on the docket. Now compare that to when the judge becomes aware of this by virtue of Katie's objection. What is the outcome? The outcome is that the motion is denied. It not only does not get heard on that docket day, it never gets heard at all because it's not on the merits. It has no merit. That is a really big deal once you understand that. These emails evidence that. So that is a more sedate way of evidencing just an example of the kind of special arrangements, not in conformance with the rules, not in conformance with the law, that has obviously, to which I very much object. And objecting to it and talking about it, not because it's my particular case, although in the context of my particular case, I did object to it because it is objectionable and I do care about it that way. But the reason it's on Facebook is because it is an illustration of a larger systemic issue, clearly, which definitely involves private actors acting not in conformance with the rule to ask judicial actors on the inside, not authorized to grant certain relief, who in the past, as this example illustrates, have granted that relief, not being authorized to do so, and granting relief not authorized by law to be given. It's an example of that, and a circumstance where that is perfectly clear, because when the judicial officer when he finds out, the judicial officer, the only officer authorized to grant the relief by rule, when that person finds out, comes back and says, no, the thing that the private actor below, the judicial actor, gave to the private lawyer who inappropriately asked for it and which was inappropriately given, that thing they are not entitled to under the law. And no, they don't get it. Guys, that's a big deal. That's a really big deal. It's not an example that has a lot of, it's not in and of itself that big of an example, but it's an example of the kind of thing
that I've been objecting to all along. Because here's the thing, special people don't get special treatment. That's a super uncontroversial proposition, and I think we can all get behind that. Okay, there's only two people, really, I think, consistently, who probably disagree with that because, as illustrated by this example, special treatment, not in conformance with the rules, has been going on. And the people that want to blow me up to hell and back and who have specifically singled out these videos in the hate notes that have been circulated have specifically cited these videos. You can put two and two and two together. My point is, guys, special people don't get special treatment under the rules. And when you see that happening, and you're in a position to object, and you understand that no one else is because they fear retaliation, and you understand that it affects people's fundamental constitutional rights that go right to the heart of the fabric of our society, their children, when this kind of thing is going on, something as a lawyer I've never seen in 20 years of practice that offends me in every way and should offend everybody. It is repugnant to the constitutional rule of law-based system that we're a part of. When I see this going on, with all due respect, hell yeah, I stand up against that. I stand 100% against this. I stand in favor of the rules. I stand in favor of treating everybody the same way. I stand in favor of doing things the right way. I don't know what to tell you. And if that gets me on the front page of a paper because people want to blow me up for exposing this kind of thing, it gets me on the front page of the paper. What I rely on is the truth, which is right here. And in my experience, the truth has a way of coming out in the end. And if you're persistent, you're on the right side of truth, things are going to end up where they should be. Maybe not for me, but for the system. And that's my interest here. God bless. Hey everybody, once again, I've gotten interest from the news media about certain things, and in response to the Courier Journal article that was so kindly written about me. I've answered a lot of the same questions. More than anything, the purpose of these videos is to say one time what I end up saying multiple times. And it gets kind of overwhelming that way, and I'm sure you can understand it's just more efficient to do it this way. The only social media kind of platform that I've ever used is Facebook, and so that's what I've used here. That's why all of this really began. So this video is about a email string that involved court actors in my in one of my cases. The date's from June of 2020. Generally, it was this incident that inspired me to believe that I needed to take a more active role as a lawyer in my own case, as I did find this incident extremely disturbing. It was after this point in time that I made an appearance in my case as my own attorney, one of my own attorneys, and at times took a lead role. I did not do that before this, but the incident took place in June of 2020. It occurred in relation to a court order that came out that was extremely significant, and perhaps the only ruling in the entire case, either case, that's been in my favor. I'm not sure that's the case for sure, but the essence of the ruling was that I get to see my daughter, roughly half the time. Not quite that much technically on paper, but in practicality, that's really the gist of it. Every other weekend, and a couple days during the week, overnights the whole time, and that was obviously after a year of waiting for a court hearing, which in part wasn't necessarily the court's fault. We had COVID delays and that kind of thing, but after a year of my daughter being in my life, obviously, and seeing her very, very, very little, very, very little, I was delighted to have the opportunity to be a dad, and for me, that's what it's all about. So that order came out by the court in some point in June, and it set an effective date. The order was going to become effective. I would start having my daughter on weekends and during a couple of days during the week. And by the way, weekends in domestic parlance are Friday through Sunday, so that can cause some confusion, I've learned, right? So here's how it works. You have every other weekend, and then there's 4 remaining days, right? So if, those are generally split, right? At least in my sort of circumstance, or at least, I have the kids overnight one of those nights, and I have them a significant period of time, but not overnight the other night. So it's not quite 50-50, but darn near, okay? Now, you can, if you want to look at it differently, you can come up with kind of different proportions, and those that have an interest in doing that sometimes do that, but more or less, it's just not that hard, and that's the way it is. Now, the particular incident in question involves what happened after the order went on in relation to my youngest daughter. Again, I wouldn't be talking about any of this stuff had it not been put into the public domain. And if there hadn't been a major article just written about it, that was grounded in court orders that have yet to run the system. My comments on that have been, I'm not talking about that. We need to respect the process. But this is other stuff related to the same litigation that I'm getting questions about now on account of the news media interest generated by that article. And I do welcome this interest, in that my purpose the whole time has been to use my case not as a focal point, but as an illustration, and an illustration only of a bigger point, which points to a systemic issue. This is an example in my case, it's not the only example in my case. I think I've talked about other examples in other videos. So it's not only an example of something occurring in my case, but the bigger point is that the type of conduct on the whole, of which this is but one example in my case, and of which there are countless more examples in my case, the genre of conduct is just one example of the kind of thing, the kind of systemic issue that clearly has affected other cases, judging from the overwhelming reaction of other members of the public. And the purpose of talking about it has nothing to do with this example, really. It has nothing to do with me. It has to do with illustrating the systemic issue for the purpose of raising public awareness, ultimately for the purpose of correcting something that needs to be corrected, to put it mildly. And so I think that's appropriate to understand. So in June of 2020, an order came out which allowed me to be, a dad in the way that I've sought to be a dad. And the other side didn't like that very much. They first asked the court to reconsider, in other words, to undo that order. The court declined. By the court, I mean the presiding judge. There was at least one motion filed that way. To my memory, there may have been more than that. It was heavily contested. At this point in time, the presiding judge went out of town. When the judge went out of town, an email was sent from the an emergency motion was filed and sent to the appropriate court actor. And a series of emails were initiated and begun at that point. I have 8 pages here in total. That when I came to be aware of these, and part of the point was that I was not only was I not, but my counsel was not at the time, I became extremely disturbed by them. I won't go into tremendous detail other than to say that the correspondence was sent to my old attorneys. And by that point in time, it was clear who my current attorneys attorney was. And accordingly, neither my current attorney at the time nor myself obviously were aware of what was going on until significantly downstream. And it's not appropriate really to go into, I don't have time to go into detail about all of these, but I draw your attention to the email I just showed and the email I just showed here, which reflects very specifically that the actor on the other side, the private lawyer who was communicating with the court, obviously well knew at the time who my lawyer was and had been communicating with my lawyer about such things. But for whatever reason, that particular lawyer was not copied on these emails, and my old lawyers were. The effect of which was to obviously have most of this happen in the dark until, and no opportunity to present objection to it until, despite the issue having been ordered, or the matter having been, despite the presiding judge in my case having ordered certain things, and again, reordered them, or essentially declined to change them, and then going out of town, an effort was made to prevent that order from going into effect by obtaining a special judge, which requires a tremendous amount of effort
and especially on short notice. That effort was made by the judicial actor in question here, the staff attorney for the presiding judge, and these emails demonstrate that. The effect of which was to set up a court hearing with a separate judge for the purpose of deciding whether to stay the enforcement, in other words, to make sure that the presiding judge's order, which he had ordered and then declined the opportunity to unorder, essentially, to make sure the purpose of getting the new judge was to yet again attempt to prevent the presiding judge's order from going into effect. The presiding judge being on vacation at that time. To my shock and horror, and we only found out about this downstream, obviously, because my attorney was not copied on this, a hearing was set up for that very purpose with a different judge. And the issue became what to do about that. Luckily, at the last moment, the judge indicated that the hearing would not be something that should happen, obviously, and that judge declined to have the hearing. And here's an email outlining what the judge said when it was finally understood what the hearing was about. That is a follow-up to this particular email, which illustrates what that judge said. Upon further review of the motion and attached report, the new judge has instructed to advise that he does not consider this to be a true emergency situation warranting an emergency hearing. Therefore, he will not have a hearing on this. The presiding judge will review the motion upon his return and determine when it will be heard. It was never heard, and I mean, what the emergency motion wasn't heard with the presiding judge because the underlying issue had already been ruled on twice by the presiding judge and gone out before he went out of town. The obvious purpose of all of this was to basically try and do what had been twice denied the folks in question, and to do it in a way that was quite secretive, if this is properly understood. This was extremely disconcerting to me. There are specific rules in place that address what types of communications are appropriate to be had between private lawyers with business before the court and judicial actors at the court. The judicial actor involved here, and what shows up on the emails, is the judicial actor that, well, once again, whose name arises in connection with several of the other issues that I have spoken about. And I don't think that's necessarily by coincidence, but my purpose in pointing this out is that this is the kind of backdoor off-the-record system. All of these things are now part of the record, but they were not part of the record at the time. This is the kind of thing that is completely inappropriate, that amounts to special favors for special people, and we cannot have that kind of thing in a court system. I do not think that this kind of proposition is all that controversial. And at the end of the day, what is this about, Ben? It's about the rule of law, which means everybody being treated under the law and judicial business being handled in conformance with the rule of law. And the rules apply to everybody the same. If we are not doing things the way that the rules say that we should do them, for certain people, we are granting special favors to special people, and that is a big problem. And the entire integrity of the judicial process is subverted. I knew at the time, or suspected at the time, that I am not special. And if this kind of thing was happening in my case, it was almost certainly happening in other cases. As it turns out, that is plainly the case, given the amount of outreach that this kind of thing has generated in my publishing or drawing to the public's attention these kinds of things occurring in my case. And that was sort of precisely the point. So I hope that makes sense, and that's what I have to say. Hello, everybody. Thank you for your interest in the subject. Now that the news media has taken an interest in the subject matter, I received quite a few inquiries about various things, and I'm happy that some of the issues that we've been talking about for a long time are getting looked at. It is unfortunate that it took
an article in the Courier Journal that was a hit piece on me to generate the media attention that, very frankly, I have encouraged for a long time about the story that I think is a story, which is the systemic problem in the Kent County family courts generated by what I have characterized respectfully as a relationship between certain judicial actors in a position to affect the process, if not dictate outcomes completely outside and without the knowledge of the presiding judge, the judicial officer authorized by the people to act, being used in a manner to give special favors and special justice to special people. That is the thesis of what I have been saying this entire time, and I have endeavored to use my litigation not as the point itself, but as a way to illustrate the bigger point which I just described. So that is kind of what's been going on. I'm encouraged again that on account of the hit piece against me, which I've declined to specifically address out of respect for the process in my cases, which hasn't remotely run its course, about which I've put out videos prior. I've declined to speak specifically about that, but I have endeavored, as I have the whole time, to bring to the public's attention certain things that are in the public domain that the public may not otherwise be in a position to connect the dots, but which but those dots being connected present a respectfully very clear, very overwhelmingly compelling, in fact I would argue undeniably and objectively, almost mathematically, indeed mathematically, empirically, compelling conclusion that we have a major problem that needs to be fixed. And so that's what this is about. Now, this I've talked in the past about findings of fact, and there have been, in fact, the recent article was about findings of fact, or premised, grounded in certain findings of fact that were determined by the Kent County Family Court in my cases. Now, those orders are not final in the sense that the judicial process has yet to run its course. Our process accounts for mistakes being made, and that process hasn't run its course. So it's interesting that we would get excited about any order, very frankly, at the trial court level at any point, given that if mistakes were made, that's something to be determined at the appellate level, and that process hasn't run its course yet. If we have problems and findings of fact that withstand appellate scrutiny of the kind that there are now, I understand a lot of questions coming my way. I don't understand that before we reach the end of the process, particularly in a circumstance where frankly, I think it very obvious that there are some very obvious motivations by those in a position to retaliate against me for making the objections that I have really for over a year now, hopefully respectfully, standing up to object to things I think are objectionable, which is the manipulation of the court system to benefit private actors and granting special favors to special people, inconsistent with the rule of law. So that's where we are. Now, about the findings of fact. I've done a couple videos about this. I'm not the only person to complain about this. There are other actors. There are court-appointed actors involved in my litigations who have spoken to these issues. So I'm hardly the only one to complain about the court's findings of fact or about how the court wrote about certain things in its judicial orders. It's important to understand here we're not talking about things where it's a matter of opinion. We're talking about witnesses coming in and taking the stand and telling the court certain testimony, and then those witnesses receiving a copy of the court's order where the court itself describes their testimony, and those witnesses thinking, wait a second, that's not at all what I said, it's certainly not what I meant, what happened here? That's not what I said. That is the kind of situation we're talking about here. So without getting into it in super detail, I did want to point out for the public record that in the two major orders in my case, again, using my cases that's not the point, is to illustrate the point. But two filings were filed that were very substantial, and they were motions under Rule 60.02D, which allows for orders to be set aside on the basis of fraud affecting the proceedings. These are in the record, people can find these. But I wanted to draw attention to certain charts that were made by my folks in the lab, who took the actual videotape record of the proceedings and compared it to the court's findings of fact, and pointed out all of the findings that were objectively wrong, not meaning that what the court wrote. When I say the court, of course, there's a certain person who writes the court's findings of fact. All of the findings that were described inconsistent with the video record. In other words, a witness says the traffic light was red, but the court order finding of fact says that the witness said that the traffic light was green. You know, we're not talking about things as a matter of opinion here. These charts, which are over 25 pages long and which contain cites to the specific date and time stamps of the video record, so anybody could verify whether we're right or wrong. And nobody has suggested that we're wrong, because we're not. All you have to do is look at the videotape, compare it to the finding of fact in the case, and any Tom, Dick, or Harry could understand that's not right, okay? So these 25-page charts, which are attached to the court filings, which seek to set aside, or sought to set aside, the orders that, the two main orders that are involved here, and which of course served as the underpinning of the Courier-Journal's article, review of which has not yet taken place, is not yet final. I wanted to point those out for people to find. Now, I wanted to draw, just by way of an example, people's attention to certain findings. So here's one from this particular case. These are all matters of public record, and here's the chart attached here too. And you know, there's tons of examples, but in this particular example, it talks about a finding that was made by the court. The Kentucky Cabinet for Health and Family Services. Hey everybody, I wanted to make another point about the litigation, and it is this. I understand that, you know, we have human actors involved, and, you know, people make mistakes, and I also understand that, you know, people can have different viewpoints about different things. I am a lawyer after all, and we're in an adversarial system, and I think we can all understand as adults that we all can see things different ways. And just because I see it this way doesn't mean that that's necessarily truth. You know, there could be, you know, somebody else might see it a different way. And so, you know, I get that kind of thing. And at the end of the day, if the court, you know, thinks that something's the case and, you know, the evidence supports something and I think that it doesn't, I mean, it's every day of my life, quite literally. It's my job to understand that. But that's a different circumstance than the court not doing the work to find an answer that exists, that is objective, that can be found out if it does the work. That's a different thing. So on the one hand, you have, like, you know, let's say two witnesses. One says the light was red and the other says the light was green. Well, it can't be both. And the court has to make kind of a credibility determination in, you know, determining what's factual. And at the end of the day, if I say that the light's green and the other side the light's red, and the court goes with that version of things, and that's all there is to it, you know, I have to respect that. And, you know, that's part of the system. But that's a very different circumstance than, for example, you know, if one party says, okay, the others, I can't, you know, deal with this person because they overwhelm me with communications. Their volume of communications is harassing and, you know, and just overwhelming. Okay. Well, if all of the communications between the parties are put into the record, all the court has to do is go do the work and count them. And if that's done, if it turns out that the party's saying that the volume of communications is so overwhelming, they themselves, it turns out, sent more communications on the whole, you know, the full amount of the entire period of time. It's a little bit ridiculous, I hope we can all agree, for that person to suggest that somehow the other person's communications to them were overwhelming or harassing. I mean, it's just, you know, that's an answer that can be found out. You don't have to believe either side. It's really a matter of arithmetic. And more than anything, it's a matter of doing the work. And that's particularly the case when you have a situation where that information is put before the court and the work has already been done for the court. You know, the court doesn't have to, like, do this itself. It just has to check the math, so to speak, of one of the parties, you know, who's already done it. And in that circumstance, it's there's really no excuse, to be honest with you, for the court getting it wrong, because it's not a matter of the court getting it wrong per se. It's not a matter of judgment. It's a matter of not doing the work. The answer is there. You just have to do the work to get it. So This is something that has troubled me in my litigation the whole time. Again, using my litigation not as the point, but as a way to make a bigger point about, some things that are disconcerting in general. It's very disconcerting that a court would deny somebody their fundamental constitutional rights because they didn't do the work to get an answer that if they did the work, they could get, and that exists right there. And that's exactly what happened in my particular case. Again, there's ways to, address that issue, but that's not the point. The point is not my circumstance. It's the fact that that could ever really happen, and clearly is happening to other people, not named me. So just by way of illustration, in my particular litigation, there were some findings about, how the level of communication from me to the other side was harassing and overwhelming, and all kinds of horrific findings of fact that the court made on that point, and ultimately denied fundamental constitutional rights of the most important kind, the most basic kind, on that basis. And yet, to rebut specifically that suggestion, which had been made ad nauseum, and frankly still is, and that, as you can understand, gets a little tiresome if you're me, because the actual objective facts are that if you look at all of the correspondence, okay, on the whole, every different kind, email, text, all different, whatever it is, call log kind of stuff, the amount of communication coming in to me was more than going in the other direction, making a determination that somehow, mine were overwhelming, just a little bit silly, more than a little bit silly. I mean, just ridiculous. And the fact that a court would have all of that information and would simply not do the math, not simply do the work, and in not doing that work, make a finding on which basis somebody would be denied fundamental constitutional rights is very scary. The court should do the work. We should be doing the work. And the question is asked, why isn't it? That's particularly the case when you have, in my circumstance, a summary chart. The work's already been done for the court, more or less. That is introduced, okay, as part of the litigation under the rules. And the court really doesn't have to do all this itself. It simply has to check the work that's been done by one of the parties. That's not good. And I think it's a fair point to say, if you're being paid by the public, it's really important to do your job. It's always important to do your job, but it's a breach of the public trust to be paid by the public to do your job and not do it. And it's really scary when the consequence of not doing it, for whatever reason, is that answers that are objective that could be found aren't found, and findings of fact are made that are extremely consequential to the tune of denying, someone their fundamental constitutional rights because somebody just doesn't do the work. That's another aspect of this that I found, not only troubling, but really offensive as a litigant. I mean, look, we don't have a right to an outcome, okay, but I think we all have a right, it goes without saying, to be heard, to have people, look at our evidence, for a neutral party to say, okay, I'm going to hear you and look at your stuff, and I'm going to hear you and look at your stuff. And then, you've got no objection to, what that person decides in the end, and you might disagree with it. But that's different than, simply not being heard and having objective evidence that if the court, if people did the work and, they could find the objective answer that prevents, fundamental injustice. So I think it's a really important point. So I wanted to make that point and kind of, just put that out there. There's really no excuse for getting something like that wrong, that consequential, that affects a litigant before the court and countless others to that magnitude, all because somebody who is paid by the public doesn't do their job. I think it's a fair point.
Hello, everybody. You have viewed all or some of a compilation of videos that reflect circumstances and events that have occurred in the context of my own personal litigation and should not have. I respectfully submit. As I stated at the beginning of this video, my purpose is not me. My purpose is not my cases. They have no larger public concern. My purpose instead is to use my cases, the materials that you've seen, the videos that you've seen, as an illustration, as an example, to make a bigger point. And that point is a public concern, is very much a public concern, and clearly has been a public concern, something that was surprising to me at first, but which I've come to embrace and accept as very much a reality. I have endeavored to consider how my personal experience might contribute to the betterment of the collective whole. In the process of thinking about that, it occurred to me that I have uniquely been in a position to document and to talk about certain things that others are not in a position to document, and especially to talk about. And I have decided that it is the right thing to do on whatever level to document and talk about these things and to publish these things such that whatever good may come of them comes of them for the collective good. I am very proud of the fact that we have achieved positive change already. Certain of the objections that I've raised, that Ms. Lawrence has raised, have led to reform of whatever kind, albeit minor, even in the form of recommitting to following certain rules that maybe in the past have not been so scrupulously followed or even known. There's been various examples of this, and while I'm proud of that, I can't help but think that the mission here is far more transcendent, is far more fundamental. And the more stories that I hear, the more tales that are told to me, the more I come to believe that there is something here fundamentally and foundationally that is wrong, that needs to be made right. Not for me, and not for those who've told me what they've told me, but for everyone. There are those who, like me, many years ago would have no interest in the subject matter involving the family court because selfishly I had no use for the family court. But as I've come to understand, it is vitally important, and we have a collective interest at all times, in all ways, in ensuring the integrity of the process of our public institutions, most especially our independent judiciary. Nothing is more foundational or fundamental to our way of life, to what we believe in as a society, as a community, than our families and the safeguard and protector of the integrity of those families and the parents that constitute them is in fact our family courts. If we do not have family courts that are premised on a rule of law based system, that do not operate in a way consistent with the rule of law, a system where special people get special access at special times and special circumstances, where justice is relationship based as opposed to rule of law based, where any of these things occur, we have a system that is destined to produce profound injustice, and that a kind of injustice that hurts human beings, and indeed the weak and the vulnerable amongst us, most especially kids, and those parents who can't afford the kind of justice that perhaps can be arranged at the right price. This is wrong. This is wrong. And I've set out to make it right. I've felt called, for whatever reason, silly as it may sound, to contribute my own personal experience, understanding, after a lot of prayer and reflection, that, like it or not, I have been in a position to contribute more than most, and have been called to do so. I hope you have enjoyed the video. I hope it's been educational for you. But in concluding this educational attempt, I'd like to end where we began, by making very clear the purpose of making the videos, publishing the videos, and the other materials, and of raising public awareness about this. It has been and is to accomplish positive change. It is to make the world a better place. It is to take what I perceive to be, shockingly, a deep wrong and to make it right, such that those who come after may have the benefit of a court system that has integrity, that respects them and their inherent self-worth as human beings,
that treats them equally under the law, and so that no litigant, as has been described to me, walks into that place with a knot in their stomach and fearful of the unpredictable justice that may be dispensed. There is nothing unpredictable about the rule of law. There is nothing unpredictable about basic notions of the equality of man and women. There is nothing unpredictable about anything related to a court system when it operates the right way. We need public institutions that do not instill fear in the hearts of those who pay for them, but instead instill confidence. Not that any one person is entitled to their particular outcome that they think should obtain, but that every single person can have confidence that their voice will be heard, their facts will be considered, and the law that has been legislated by their public representatives will be followed. It is for that purpose that this video has been compiled. It is dedicated to the countless courageous men and women who have come forward to tell me things that they have never told anybody else, who have exercised courage and bravery, and increasingly stepping out of the shadows and recognizing that they too have been a part of a system which has failed so many, but they might have a role in correcting it for so many more, who have been inspired by each individual collective person that has dared to step out of the shadows, to speak about things that are difficult to speak about, to which a stigma is attached in some certain circumstances. And one by one, initiated a quiet revolution such that a chorus of disparate voices, quiet and isolated in the abstract, can come together as one and can be galvanized, and has been galvanized, into a louder and louder collective voice demanding change. It was not my intent to be the face of whatever movement or effort that is. I would rather, very frankly, not be in the position that, as a matter of duty and conscience, I feel that I am in. But none of that matters in the end. What matters is I am right here, right now, in this position. And I have felt compelled, inspired by the bravery of so many others, and the tales of so many others to whom this is dedicated, to speak out and speak up, to embrace every consequence of doing so, knowing full well the consequences of saying what I have said, to suffer personally and as a family matter the consequences that I had hoped I could avoid, but in my heart of hearts knew that I would suffer, and stand right here, right now, to contribute what I have to contribute. This is what I have to contribute. This video compilation reflects much of that. I hope very sincerely that it does accomplish positive change, that it helps, that it inspires, that it contributes in publishing the truth, that it accomplishes something good, something positive. And I appreciate you watching it.